This session is going to be on the Secure Act and the changes in legislation that actually took place at the end of last year. There we go. Before we dive in, I'll give you a little bit more background on myself. I'm Jenna Franks. I'm one of the attorneys and the partners at Steinbacher, Goodall, and Yurchak. I operate primarily out of our State College and Altoona office locations. Pictured here with me is my husband, Josh, and our two kids, Ava and Grayson. This picture is a little outdated. Grayson's now 3, and he causes a lot more chaos than it looks like in this picture. So that's my family, a little bit of background on me. Now, for those of you that don't know, our office is an elder law firm, which means that we focus the bulk of our time on planning for a client's second half of life, whether that's planning for death, planning in case a client gets sick and needs care, or planning for retirement. We end up working with quite a few clients that have dementia or some sort of a cognitive issue. So we've spent a good deal of time at our office educating ourselves on the best way to interact with those clients, and also make sure that we're just doing the best job advocating for them and making sure that their wishes are met. We also work with a lot of clients who, or even the client's children, who have a condition or a disability whereby they might require some sort of government benefit help. Oftentimes, that really comes down to special needs planning, is what we call that. And since our line of work naturally involves with dealing with many clients that require some sort of care, we find it very beneficial to have social workers on staff. So at each of our offices, you will see that we have several different social workers. Their jobs are somewhat different. Basically, oftentimes those social workers are handholders, as our clients are transitioning through some of those difficult periods of life. We've included those social workers into a plan that we actually offer to clients now, and we call that elder care navigation. Basically, what that is our social workers are helping clients navigate through those troubling times in their life. So elder care navigation is now that's a newer service that we offer at our office, and that's really what that comes down to. So why can some of these times be troubling? Well, here's a joke that emphasizes one possible reason. How many of you have dealt with a familiar situation to this? Probably most of you, I would imagine, if not all of you. One good and bad thing about doing this from home is actually my dog's right here and insists on having lots of attention. So if you guys hear him or anything, that's what's happening on my side. All right, so the Secure Act. The Secure Act became effective at the end of 2019, really the beginning of 2020. The act was designed to make retirement planning more desirable, both for employers and employees. The act established that RMDs could now be taken at age 72, which is a big deal. It had been 70 and a half previously. The act also established that an employee can contribute to their IRA past the age of 70 and a half. I have had clients actually come in and ask if they can still contribute. It's not that common, but there are clients that still would like to contribute. And also both long-term and part-time employees can enroll in their company's 401k. It does depend on the number of hours that they're working, but that's definitely a possibility. One of the biggest downsides that we've seen as a result of the Secure Act is that when your children inherit your IRA, they no longer automatically get that lifetime stretch out for taking RMDs from the plan. So now your children or your beneficiaries, they're going to be considered in one of these 3 categories: an eligible designated beneficiary, a designated beneficiary, or a non-designated beneficiary. If your beneficiary is an eligible designated beneficiary, then they will still benefit from some type of life expectancy payout. So to give you a hint, the best category for your beneficiaries to be in is that first one, to be an eligible designated beneficiary. Designated beneficiaries, they actually have to withdraw the entire amount from the IRA plan within 10 years. Most individuals in see-through trusts will fall into this category. And then that third category is a non-designated beneficiary. Those beneficiaries typically have to withdraw the entire IRA plan within 5 years, unless the owner died after the required beginning date, in which the RMDs would then be based on the owner's life expectancy. So oftentimes where we might see a non-designated beneficiary is when like a client actually makes the beneficiary of their retirement account just their living trust or their revocable living trust, rather than specifying the actual the beneficiary's individual trust within there. That's typically considered a non-designated beneficiary. You really want to be particular. Like if we have a revocable living trust, like Julie had shown earlier, that ultimately creates maybe 3 different trusts for the children ultimately, then the beneficiaries on that retirement plan should say, this child's trust under, this living trust. It really needs to be particular. It can't just say, my client's living trust. It has to actually specify each of the children's individual trusts to get the designated beneficiary status. So that's something definitely to keep in mind. And we do see those kind of errors from time to time. It can make a really big difference. So who qualifies as that eligible designated beneficiary? This can be especially helpful for special needs planning. I end up working with quite a few clients who have large IRAs because we're right around Penn State. And so oftentimes if those clients have, one of their children has requires some sort of government benefits, they have a disability, then I'll talk to them about the fact that if we set aside more of the IRA funds for that child who has a disability, it might be a lot more beneficial from a tax standpoint because they get that lifetime stretch out for their portion of the IRA that they inherit, versus any of the other kids who don't have a disability. Those kids will have to inherit the IRA over that 10-year time period because they'll just be a designated beneficiary. So definitely something to keep in mind if you have a family, maybe there's a large IRA, one of the children has a disability, definitely consider making that child with the disability the beneficiary under that plan. All right, so we're actually going to jump into our first poll question already. All right, so the Secure Act allows an individual to contribute to their IRA past age 70 and a half. True or false? Good. Yes, so that is true. That is true. That is one of the benefits of the Secure Act is you can now contribute to an IRA past the age of 70 and a half, where previously, once you start taking the RMDs, you can no longer contribute. So one of the good things that came out of the Secure Act. All right, so next we're going to talk through some of the different trust planning that we use at our office, and we'll discuss how the Secure Act has affected that type of planning, especially with trust in particular. So we typically have 2 types of trusts that we use for holding inherited IRA funds: a conduit trust and an accumulation trust. A conduit trust has provisions so that any RMDs coming from the IRA plan are paid to the beneficiary. The trustee must distribute the RMD as it's received. So those funds are not held inside the trust. The RMDs go to the beneficiary each year. Pre-2020, before the Secure Act, we used the life expectancy stretch out, and those RMDs would be distributed to the beneficiary over the beneficiary's life expectancy. Now, after the Secure Act, post-2020, this would still hold true for eligible designated beneficiaries who still qualify for the life expectancy stretch out. So those eligible designated beneficiaries can still benefit from a conduit trust as long as they continue to be a qualified eligible designated beneficiary. After the Secure Act post-2020, with most beneficiaries being subject to that 10-year rule, being just a designated beneficiary, a conduit trust could be very troublesome to a beneficiary, especially depending on how the RMDs are taken over the 10-year time period. So this type of a trust could really cause significant tax consequences for the beneficiary of an IRA. So definitely something to keep in mind as we look at conduit trusts moving forward. Then that second type of trust, the accumulation trust, as the RMDs are taken from the IRA plan, the RMDs are held inside the trust, and the trustee has the discretion to determine when any money should be paid to the beneficiary. In this type of a trust situation, the RMDs are not automatically given to the beneficiary. The stretch out for this was based on the life expectancy of the oldest beneficiary. Any money held inside the trust is taxed at the trust income tax rate, which tend to be pretty high. It's usually 37% over, I think it's like $12,000. So trust income tax rates are not usually that beneficial. When we had the lifetime stretch out, those RMDs were less significant in amounts, and so this money was being held inside the trust was not as much of a big deal. Now, post 2020, if the trustee decides to give the RMDs to the beneficiary, again, this could significantly affect the beneficiary's tax situation. But if the trustee decides to hold the funds inside the trust, then this money inside the trust is taxed at that trust income tax rate of 37%. So the bottom line here is that it's important to revisit any IRA trusts that were set up prior to the Secure Act so that we can make sure that they're in the future, they're set up in the most beneficial way for the beneficiaries. We're still meeting the needs of, the grantor, but also the beneficiaries as well. So next poll question: which trust uses the life expectancy of the oldest beneficiary, a conduit trust or an accumulation trust? So it's the accumulation trust that uses the life expectancy of the oldest beneficiary. All right. So I mentioned that the tax laws have recently changed, right? Because the Secure Act was implemented 2020, but again, now we have the Secure Act 2.0. So let's talk through some of those changes. So we heard a lot of discussion about these updates, and President Biden officially signed this new legislation into law on December 19th, 2022. There was a lot of going back and forth. It seemed like all of 2022, at least, we were kind of going back and forth with provisions. But it's official. At the end of 2022, we have Secure Act 2.0. Some of the purposes for these updates were to build upon the legislation already in place for the original Secure Act, but also to provide some clarity for some of the original legislation, because there were still a lot of questions, and there were a lot of things implemented that we didn't really think that originally when the Secure Act was implemented that that's really what the purpose was. So we got some clarity from the Secure Act 2.0. So what's new? The original Secure Act required retirees to take RMDs at age 72. Now, Secure Act 2.0 allows retirees to wait until age 73. And that's actually going to bump up to age 75 in the year 2033. So that's kind of a big deal. I think that will be helpful to retirees. Doesn't really change much for the beneficiaries, but for retirees themselves, if they want to hold some of those funds in their retirement account because they don't necessarily need those RMDs, then that will be an option. Secure Act 2.0 also reduced the excise tax for failure to take RMDs. So it was originally in the original Secure Act, that tax penalty was going to be 50%. Now it's 25%. And this is basically effective starting 2023 with this year. There are better catch-up contributions. So over the age of 50, you can now over-contribute to catch up on your retirement savings goals, which is a good thing. So if you're a little bit behind on what you had wanted to contribute, there's a couple different ways that you can actually catch up on those contributions. This is kind of a big deal as well. So now employees are automatically to be enrolled in their company's 401k. And if the employee does not want this to happen, then they have to actually opt out of this. So very, very big difference. You historically always had to sign up to contribute to a 401k. Now it's automatic, that you will be enrolled unless you actively opt out. So if you haven't gathered already, this is the government's way of basically trying to force people to save up for their retirement, to be more active about that. The new act also expands access to retirement funds with little or no penalty when otherwise the retiree would have had to pay that penalty. So there are some emergency personal expenses built into that. There are provisions for domestic abuse survivors so that they're able to access some of those IRA funds early if necessary. Also, victims of a natural disaster, and of course they spell out, it has to actually be an official natural disaster. But if they are, if they do suffer from the natural disaster, then they're actually able to access some of those funds early with no penalty. Okay, so what we want to do here is we want to, one option to get around all these taxes that result from the Secure Act is to convert IRAs to a Roth IRA. And we are starting to see that done more and more often now. We're going to look at a few case studies though to see if this makes sense and try to figure out, what all considerations should we be making in trying to figure out if that actually makes sense for a client. So the first case study here. So we have the parents who have passed away with a $4 million IRA. Each child is set to get $2 million, so 2 kids here. Kid number 1 is 30 years old and makes $30,000 per year. Child number 2 is 35 years old and makes $125,000 per year. So let's look at child number 1 first. So 30 years old, makes $30,000 per year. This down here. So before the Secure Act, their 10-year cost would have been $148,000. The 50-year cost, because they got the lifetime stretch out for the distributions, it would have been $742,000. Okay. After the Secure Act, because this child's going to have to withdraw everything over that 10-year time period, they're a designated beneficiary, it's going to cost them $805,000 to withdraw that IRA. So a huge difference here. Their income tax rate before the Secure Act it went from 12% to a 22% tax rate. Now, after the Secure Act, we're going from a 12% tax rate to a 35% tax rate over that 10-year time period, because their annual income is about $230,000. So huge difference here for some of these beneficiaries. Then child number 2, and then just to kind of go back, child number 2 is 35 years old and makes about $125,000 per year. So what's this look like for that beneficiary for a $2 million inheritance? So prior to the Secure Act, that 10-year cost would have been about $531,000. They're getting that lifetime stretch out. Definitely more of a tax issue over the 50-year time period, but look at the difference with the Secure Act now. That 10-year cost, because they're going to have to withdraw it over that 10-year time period, $1.1 million. So huge consequences here for this child as well. Again, the tax rates, because this child was already making a good deal of income before they were inheriting this, their tax rate hasn't changed quite as drastically. After the Secure Act, it's going from 24% to 35%, but still a lot of consequences here for the second child as well. So let's change the case study a little bit and say the parents are still living. They make $7,000 per year, and we want to look at trying to prevent some of those tax consequences for the children and talk about converting that $4 million IRA to a Roth IRA. And they're currently receiving $17,000 in Social Security benefits. So let's look at the possibilities here. There's the 8-year conversion, and then there's the 1-year conversion. Because sometimes we work with advisors and accountants who are saying, let's Sometimes people are saying like, let's stretch this out so it's not one huge tax hit, in 1 year. Other people are saying like, let's just go ahead and convert everything in 1 year, and get it over with. And I think what you guys will find in going through some of these scenarios is there's no one size fits all. It really just comes down to looking at the individual clients and figuring out what the best scenario is for them. So with
Hey,
that yeah,
and Jenna, real quick, question come in through the chat. Is the auto enrollment just for 401k or is it also for employer sponsored IRAs?
that's a good question. I know it's for the 401ks. Let me check on the employer sponsored IRAs, and I'll get back to you on that. Very, very good question, though. So with the 8-year conversion, so that means that we are converting $500,000 per year out of that IRA into a Roth IRA. So the 1-year cost for that is $197,000. The 8-year cost overall will be $1.5 million. Okay. This, if you do the 8-year conversion, that's going to push the clients into a 35% tax bracket. That's going to increase their Medicare premium per year. And sometimes for clients, that's the worst thing. They don't want to see their Medicare premiums increase. And so that's what really gets them upset. And then they have that $14,000 Social Security tax per year. Versus if you look at the 1-year conversion, they just convert that entire $4 million IRA in 1 year to a Roth. The 1-year cost is huge, $1.5 million, but really, that's very similar to the 8-year cost. If you were to stretch that out over an 8-year time period, it's going to push them into that 37% tax rate for the first year, but it's just that 1 year. Okay. And then they go back down to their 10% tax bracket after that. It's going to bump up their Medicare premium to $5,800 for the first year. But then again, after that first year, their Medicare premium drops again to the $1,700 that it was previously. And then that Social Security tax, again, is just for that first year. So in this situation, kind of looking at it, because their tax rate is gonna go back down after that 1 year, their Medicare premium is gonna go back down. It probably makes sense here to maybe just look into converting that entire IRA into a Roth in that 1 year time period. So let's look at just half of the IRA to a Roth conversion. So we do $500 per year or $500,000 over a 4-year time period. Okay, so here the first year cost is $197,000. The 4-year cost will then be $789,000. Again, you have that 35% tax rate over that 4-year time period. It increases their Medicare premiums for the 4-year time period, and again increases that Social Security tax. Whereas if you just convert the $2 million in that 1 year time period, yes, you have that 1 year cost of $760,000, but that's already less than the 4-year cost of converting over a 4-year time period. Plus, so if you convert everything in that 1 year, you only, again, you have the tax rate, the increased tax rate just for a year. You have the Medicare premium just for a year, and also that Social Security tax. So this one actually already looks like it's saving the clients a little bit of money. And we haven't even gotten into, the different tax rates over years and Medicare premiums. So just another example and it's not like this consistently. Sometimes it does make sense to stretch these conversions out over several years, but this is just kind of giving you an idea. I think sometimes when we even think about converting a large sum of money like this in 1 year, it kind of makes you panic a little bit. But sometimes it does make sense. It just comes down to crunching the numbers and figuring out what works for these clients. Something else to remember is if you pay the taxes now, you lose out on the future investment income on money you have to pay as taxes. That's true. Yeah, absolutely. So with the second case study, so now parents have passed away again with an $8 million IRA. And the children's situations are the same. Child number 1, 30 years old, makes $30,000 per year. Child number 2 is 35 years old, making $125,000 per year. Okay. So let's look at what the Secure Act does for these children when we're talking about an IRA that's twice as much as it was previously. So for child number one, who has a much less income, 30 years old, excuse me, the 10-year span, they're looking at taxes of about $250,000. This is huge because look at what this 10-year time period does to them after the Secure Act. I mean, $1.5 million in taxes just in that 10-year time period. That's a huge chunk of what they're inheriting, which is pretty scary. Again, largely increases their tax rate. Not ideal. So this is a type of client situation that we try to get ahead of before the parents pass away, to try to figure out if there's something else we can do to try to save them some of the money in these taxes. And it's not much better for child number two either. Again, they were already in a higher tax bracket, so this isn't quite the huge jump after the Secure Act for that 10-year time period. We're going from $700,000 to almost $2 million. Still, though, that's a ton of money to be spending in taxes if we can try to get ahead of it and try to prevent some of those taxes, if at all possible. So then if we look at these conversions for these clients, so now parents are alive, they're making $7,000 per year. It's all the same facts. It's just that now we want to look at an $8 million IRA versus that $4 million IRA that we were looking at previously. So if we're looking at an 8-year conversion, converting about $1 million per year, that 1-year cost is about $390,000. Over the 8-year time period, we're looking at about $3.1 million. Okay. And again, as you guys know, with the 8 years, it's going to increase the Medicare premiums. They're going to have increased tax rates for that 8-year time period. If we look at the 1-year conversion, that converting that entire $8 million sum into a Roth in the 1-year time period, the 1-year cost is huge, $2.9 million. But if you look at the overall 8-year cost, this is actually already less than the 8-year cost of converting over the 8-year time period, converting much smaller amounts versus that 1-year conversion of converting the entire $8 million. So again, this could be really beneficial to look into converting just in that first year, and then having their tax rate, Medicare premiums go much lower than after that first year. And if we look at half, just converting half of that IRA over the 4-year time period, that'd be $1 million per year. First year cost would be about $392,000. The overall 4-year cost for that would be about $1.5 million, which is very similar to what that 1-year cost would be. The 1-year and 4-year cost would be if you just converted that entire $4 million in that first year. Then again, their tax rates, Medicare premiums, Social Security tax will then decrease after that first year. So like I said, guys, the bottom line here is that it might make sense to convert an IRA to a Roth all at one time, or it might make sense to convert over time. It might not make sense to convert at all. Each case is different, and it requires us to consider the client's goals and their particular situation. However, conversion could be a great option in certain situations to try to avoid some of these tax consequences that we're seeing as a result of the Secure Act for these beneficiaries. Other potential options to offset some of the tax consequences of the Secure Act are to purchase insurance. Life insurance has always been a great option to offset taxes. There's also hybrid options for life insurance that could include long-term care options. I think we've come a long way with some of these different hybrid plans. So definitely a great way to try to leverage some of these taxes. We are big advocates for these life insurances that have the long-term care riders if they make sense for clients. We think long-term care insurance is a great option for a lot of our clients who are worried about long-term care costs. So definitely a good option. And then they also have the option of leveraging that life insurance against the taxes involved here. There's also charitable remainder trust that we've used historically. A charitable remainder trust is an irrevocable trust that lets you donate the assets to a charity, but then you get to draw an annual income for life or for a specific period of time. These trusts are designed to reduce the taxable income of the individuals by receiving a partial tax deduction from the initial donation to the charity. The downside, so it can be really, really beneficial for clients who are in this type of a situation. The downside, though, is first of all, the trust is irrevocable. And also, sometimes these types of trusts can be complicated, and that makes them a little bit difficult to create and also administer. And then in time, that makes it a little bit costly to actually implement as well. So not always ideal for every client, but that's definitely a tool that we can use in the right situation. All right, so for the last portion of our Secure Act review, I wanted to address some of the criticisms of the Secure Act 2.0, and in particular, the harsher treatment of older individual beneficiaries. We're still waiting to get a little bit of clarification on this as we implement this moving forward. But our first example here, we have Jane Doe. So Jane Doe is an 80-year-old woman. She dies in 2022 at the age of 80, leaving her IRA to her older sister, Mary, who is 85. Mary's not disabled or chronically ill. Since Mary is older than Jane, she qualifies as an eligible designated beneficiary. She's entitled to receive a life expectancy payout. So that's a good thing, right? In typical situations. Mary's life expectancy, though, at age 85 is only 8.1 years. A designated beneficiary who wasn't an eligible designated beneficiary would have gotten the 10-year payout. Can Mary elect the 10-year treatment? It doesn't look like it. And according to the regulations, an eligible designated beneficiary can elect to use the 10-year rule instead of life expectancy payout only if the account owner died before the required beginning date. Since Jane died at age 80 after the required beginning date, Mary cannot elect to use the 10-year rule. This is very troubling for a lot of us because it looked to us like we wanted better treatment for eligible designated beneficiaries. And in situations like this, it's looking like that's not happening. You know, shouldn't there be a longer of rule? Previous regulations provide that during Mary's life, her RMDs will be calculated using the greater of her life expectancy or the life expectancy of Jane. However, what's happened is a lot of the current regulations are taking away that greater of language. And just basically they're saying that the benefits have to be paid from the account no later than the final year of Mary's life expectancy, even if it's shorter than Jane's life expectancy. So unfortunately, it's kind of looking like an eligible designated beneficiary situation can be worse after the Secure Act than it was before. And so, like I said, it's troubling because we don't think that was expected. You know, we don't think that was the purpose of this, but unfortunately, that's kind of where we're at right now. So we do need a little bit of further clarification on that, or maybe some updates just to see if we can fix a situation like this. Can you help Mary and Jane? Possibly by tiering your beneficiaries so that, you know, the sister can actually disclaim. There's other options. You know, if it does not make sense for the sister to claim that as a beneficiary, maybe there's other beneficiaries that would get better tax treatment. It would make more financial sense for them to actually inherit the IRA. Leaving money to the estate might actually make sense here. We don't love to do that because oftentimes that means that, you know, the beneficiaries will have to withdraw those funds a lot sooner, like over the 10-year time period. But the money here would have been paid based on Jane's life expectancy versus Mary's. So, I mean, that and this kind of outcome would have been better, but it's tricky because a lot of clients like to try to leave their money to an estate, and that could be a much worse tax consequence for a lot of those clients that aren't in this type of specific scenario. So that can be a difficult scenario depending on the detail. So not ideal here for Mary and Jane at all. A designated beneficiary entitled to the 10-year rule, all money must be paid out in the year that contains the 10th anniversary. But the IRS applies the RMD rule if the owner died after the required beginning date. That means that the designated beneficiary must take annual distributions over their life expectancy beginning in the year after the account owner's death, with 100% distribution no longer than the year containing that 10th anniversary. So let me give you guys an example of this. The example is John Doe is 94. He dies in 2022, and he leaves his IRA to his brother Jake, who is 83. Jake's not disabled or chronically ill, and he is more than 10 years younger than John. Therefore, Jake is a designated beneficiary, and he's subject to that 10-year rule. It was assumed under the Secure Act that Jake had the opportunity to withdraw the account anytime between 2022 and 2032, as long as he just withdrew 100% by that 10th year, right? Under the current regulations, it's looking like Jake actually has to withdraw annually over his life expectancy with 100% payout no later than 2032. His life expectancy is only 9.3 years. So he's not getting that option to actually take, that money over the 10-year time period as he wishes. He actually has to take the annual RMDs based on his life expectancy. And I mean, that might not be that big of a deal because he still gets to stretch it out over that 9.3 years. But for some beneficiaries, it could be really helpful that they just are able to take that when it makes sense for them, as long as they take it within that 10-year time period. So how can we possibly help in this situation? Well, could we leave it to John's estate? Unfortunately, no, because even if Jake is the sole beneficiary of the estate, John's life expectancy was only 4.3 years because he was 94. So not necessarily an option here. As we mentioned, those charitable remainder trusts, that's a possibility if John had that charitable intent and wanted that to happen. Really, and this isn't something that we can necessarily help with, but the best fix would be for the IRS to eliminate that requirement of the annual RMDs during the 10-year rule, so that designated beneficiaries are actually able to get the benefit of the 10-year rule that the Secure Act really looks like it was supposed to be mandating. So hopefully we can get some clearer answers on that, but it's good that you are aware of what's happening here and what's at risk. Options are very limited once the IRA owner passes the required beginning date. That's kind of where we're at. So if a client is age 72 and has no minor children, what are the options? You can leave the account to the surviving spouse outright. And obviously, this is better if the spouse is much younger, but I don't advocate for people getting married or getting divorced or anything like that. But it would be more ideal if they're married to a younger spouse who's likely to be able to use that stretch out over their life expectancy. Or you could consider allocating the IRA to a trust for a younger beneficiary who's disabled or chronically ill. This is what I was saying to you guys earlier. If you have that family who maybe has a loved one, a child who has a disability or requires government benefits, definitely look at whether it makes sense to add. I would not have the money go outright to the child with a disability. What I would do, though, is set up what's called a special needs trust or a supplemental needs trust, and I would have some or all of those IRA funds going into that special needs trust, so that the RMDs can be taken over that beneficiary's life expectancy. So that can be really, really helpful for some families, and that's something, if you need us to kind of talk through with you. If you have a family kind of in a similar situation to that, let us know. We love bouncing ideas off of each other and just kind of learning to see what works best for clients. You could also leave the account to a designated beneficiary trust for individuals under the age of 60. So in this type of a situation, that 10-year rule would apply. The proposed regulations interpret the Secure Act to require annual distributions over the oldest beneficiary's life expectancy. So for example, like if the oldest beneficiary is age 40, their life expectancy would be about 45.7 years. So the RMDs are only about 2% of the annual, a 2% annual distribution with 100% in year 10. So that could be helpful depending on what that looks like in year 10, right? That could be a big payout at that point in time, but something for us to look at. This could also be helpful if the beneficiary is young enough that maybe their tax bracket isn't quite that high just yet. And lastly, we could look into whether it makes sense to leave the account to a charitable remainder trust, depending on what their charitable intent is, and if they're okay with the fees to maintain that, and a little bit of complexity in setting that up.